The Clancy case is not about our emotional ideas of justice. It is about the facts. The choices being made in this criminal case have been and will continue to influence the civil suits. Patrick and Lindsay's cases are separate, but this criminal decision matters. Prison sentence means that taxpayers pay for her to be at a public prison that has a hospital but won't have much in terms of actual health care. Her win here now means the medical system pays damages, including her physical injuries. Joe Public should understand that fact as opposed to feelings. The facts actually should rile up anyone's feelings beyond the brutality. Many are concerned about her being released to the public. But the trial now is about who pays for her care for the rest of her life. What does justice mean when the costs are the concern, when malpractice is a huge consideration from a series of decisions on this criminal case? The ongoing criminal murder trial heavily dictates the legal viability, financial boundaries, and evidentiary strategy of both Patrick and Lindsay Clancy's separate medical malpractice lawsuits. Because the burden of proof is much lower in civil court, preponderance of the evidence, than in criminal court, beyond a reasonable doubt, the criminal trial acts as a massive evidentiary preview that will reshape the civil claims in the following ways. 1. The legality of Lindsay's civil claim, the Slayer rule. The outcome of the criminal verdict will determine whether Lindsay is legally allowed to pursue or benefit from her lawsuit at all. 1. If found guilty, under Massachusetts law and the public policy principle known as the Slayer rule, a person cannot financially profit from their own criminal acts. If the jury convicts Lindsay of first-degree murder, her civil lawsuit will likely be immediately dismissed or barred. As she cannot seek civil damages, such as mental health and paralysis care as well as loss of wages and profession, stemming from an event where she was deemed a conscious criminal actor. 2. If found not criminally responsible, insanity acquittal. If the jury agrees she lacked criminal responsibility due to postpartum psychosis, she is legally considered a victim of a medical defect rather than a criminal. This would clear the path for her civil suit to proceed, allowing her team to argue that the medical provider's negligence directly caused the psychotic break that ruined her life. 2. A ready-made roadmap of expert testimony. The weeks of dueling testimony from world-class forensic psychiatrists have essentially done the discovery work for the civil attorneys. The over-medication defense blueprint. The civil attorneys will heavily weaponize the criminal defense team's evidence regarding polypharmacy, the fact that Lindsay was prescribed 13 different medications in a short window. The testimony of Dr. Jennifer Tufts and other providers has already exposed vulnerabilities, such as a complete reliance on remote telehealth sessions and a failure to coordinate with other treating clinics. The bipolar diagnosis alignment. Because multiple experts on both sides, including state-called forensic psychologist Dr. Kirk Halbran and the clinical team at Tewksbury Hospital, formally testified or concurred that Lindsay has bipolar II disorder. The civil suits now have a rock-solid foundation to argue that the outpatient doctors completely missed a major, underlying mood disorder diagnosis while erratically switching her medications. 3. Isolation of Patrick Clancy's wrongful death claim. Unlike Lindsay, Patrick Clancy's civil suit is entirely insulated from a negative criminal verdict. Because he is an innocent party who is suing for the wrongful death of his children, his case will move forward regardless of whether Lindsay is sent to state prison or a psychiatric hospital. If Lindsay is convicted, Patrick's civil team will argue that the doctor's gross negligence was the proximate cause of the family's destruction. They will position the medical providers as the primary entities responsible for the medication mismanagement that destabilized the household. If Lindsay is acquitted by reason of insanity, Patrick's case becomes exponentially stronger. A criminal finding of legal insanity establishes a court-recognized fact that Lindsay was entirely out of touch with reality. This will allow Patrick's civil lawyers to argue that the doctors unconscionably missed severe, emergency-level psychosis warnings, leaving a severely sick woman completely unmonitored with 3 small children. With closing arguments expected to begin tomorrow, Thursday, the criminal verdict will provide the final legal green light, or roadblock, for these multi-million-dollar civil claims. If you would like, I can track the jury's deliberations once they begin, or break down the legal standard of preponderance of evidence that Patrick will have to face in October. How would you like to proceed? 1. Influences on Patrick Clancy's civil lawsuit. Patrick Clancy's medical malpractice and wrongful death lawsuit against Dr. Jennifer Tufts, Astor Mental Health, nurse practitioner Rebecca Jolotta, and South Shore Health System is highly insulated from the criminal trial's final verdict. Because he is an innocent party suing for the wrongful death of his children, the criminal standard of proof, beyond a reasonable doubt, does not apply to his upcoming civil case in October, which relies on a lower burden of proof, preponderance of the evidence. The criminal trial directly influences his civil suit in three primary ways. The ultimate defense shield, the liability challenge. Attorneys for the medical providers have already asked a judge to dismiss Patrick's lawsuit. They argue that under Massachusetts law, mental health providers are shielded from liability for crimes committed by their patients. If Lindsay is convicted, the defense's statutory liability shield becomes stronger. The providers will argue that Lindsay acted as an independent, calculated criminal actor. This breaks the proximate cause link between their prescription adjustments and the ultimate tragedy. If Lindsay is acquitted by reason of insanity, Patrick's civil case becomes exceptionally powerful. An insanity acquittal establishes a court-recognized fact that Lindsay was completely detached from reality and suffering from acute psychosis. Patrick's lawyers will use this to argue that the medical providers committed gross negligence by missing emergency-level psychosis warning signs and failing to monitor a severely unstable patient left alone with 3 small children. 2. Legal intersections with polypharmacy and medication lawsuits. The core of both Clancy civil suits rests on the concept of iatrogenic harm, injury caused by medical treatment, specifically severe polypharmacy. Between October and December 2022, Lindsay was prescribed a rotating cocktail of roughly 10 to 13 different psychiatric medications, sedatives, and mood stabilizers. This case connects to a broader legal landscape of lawsuits involving rapid medication switching and black box warning failures. Paradoxical medication reactions. The suits claim the rapid introduction and withdrawal of powerful psychotropic drugs caused a severe paradoxical reaction. Instead of calming her anxiety, the drugs exacerbated her underlying psychiatric vulnerabilities and induced a state of manic, command hallucination psychosis. This mirrors landmark product liability and malpractice suits against manufacturers and doctors regarding SSRIs and antipsychotics, where a sudden uptick in dosage or overlapping medications triggered akathisia, a state of severe, drug-induced agitation linked to sudden violence or suicide. The telehealth regulatory gap. Because Lindsay's treatment with Dr. Tufts was conducted entirely via remote telehealth sessions, the civil suits highlight an emerging legal battleground over remote care standardization. Like recent federal crackdowns and class action scrutiny against online mental health startups, the Clancy lawsuits argue that relying strictly on virtual screens to evaluate severe postpartum disorders constitutes a systemic failure to appropriately assess patient safety. 3. Impact on women's maternal health care. Beyond the courtroom, the Lindsay Clancy case has emerged as a national symbol of the gaps and structural failures within maternal health care. The intersection of her case with women's health advocates highlights several critical impacts. 1. The diagnostic blind spot for perinatal mood disorders. Outpatient providers treated Lindsay heavily for generalized anxiety, postpartum depression, and adjustment insomnia. However, multiple experts at trial and her clinical treating team at Tewksbury Hospital later formally diagnosed her with bipolar II disorder. Women's health advocates note this showcases a deadly, systemic blind spot. Standard postpartum depression screenings frequently fail to screen for underlying bipolar disorders. When standard antidepressants, like Zoloft, are prescribed to an individual with undiagnosed bipolar disorder without a corresponding mood stabilizer, it can trigger severe mania, insomnia, and acute postpartum psychosis. The trial within a trial restriction, highlighting how the legal system struggles to handle maternal health crises. The judge in the criminal trial denied a defense request to allow 16 women to testify about their own harrowing lived experiences with postpartum depression and psychosis. The court ruled it would create an unnecessary trial within a trial, keeping the focus strictly on expert psychiatric testimony rather than systemic maternal healthcare failures. The chilling effect versus the push for reform. Maternal health advocates express deep concern that a first-degree murder conviction will create a chilling effect, terrifying struggling mothers into hiding severe intrusive thoughts or postpartum psychosis symptoms out of fear of criminalization or Child Protective Services intervention. Conversely, the civil lawsuits seek to set a major legal precedent holding healthcare institutions financially accountable for failing to provide comprehensive, inpatient to outpatient safety nets for new mothers. Question: how would this have been influenced if there is found reason to investigate or question his responsibility as a husband and his family's health? If an investigation or legal discovery formally questioned or found reason to challenge Patrick Clancy's responsibility as a husband and his management of his family's health, it would trigger a massive legal and financial shift in both civil malpractice lawsuits. While the actual criminal investigation conclusively ruled out any wrongdoing or physical involvement by Patrick, a civil trial operates under the doctrine of comparative negligence. Any evidence showing he failed to act as a reasonable caretaker would dramatically alter the outcomes of both lawsuits. 1. The impact on Patrick Clancy's wrongful death suit. If the defense lawyers for the medical providers successfully argued that Patrick shared responsibility for the unsafe environment at home, it would severely damage his multi-million-dollar lawsuit. The comparative fault, financial reduction. Massachusetts follows a modified comparative negligence rule. If a jury determines that Patrick was partially at fault for the tragedy, e.g., for leaving a severely impaired woman alone with 3 infants, despite knowing she was experiencing a severe downward spiral, the jury would assign him a percentage of fault. The over 50% bar, under state law, if Patrick is found more than 50% responsible for the lack of oversight regarding his family's health, he would be legally barred from collecting any financial damages from the medical providers. The reduction rule. If he is found, for example, 30% responsible, any financial payout awarded to him by the jury would be automatically slashed by 30%. The provider's ultimate escapism shield. The sued medical doctors and Astor Mental Health would use any evidence of spousal neglect to argue an intervening, superseding cause. Their lawyers would claim that while they prescribed the medications, Patrick's failure to safeguard the children or follow clinical warnings was the actual, direct cause of the tragedy, completely relieving the clinics of financial liability. 2. The impact on Lindsay Clancy's personal civil suit. Paradoxically, questioning or finding fault in Patrick's role as a caretaker could theoretically strengthen Lindsay's civil malpractice case against her doctors, while simultaneously introducing a new target. Reinforcing her systemic isolation claim. Lindsay's lawsuit alleges that she was completely failed by a medical network that left her isolated. If evidence emerged that her home environment lacked proper spousal or familial health oversight, her civil lawyers would argue that the medical providers committed an even greater breach of duty by failing to mandate an inpatient stay or coordinate a professional in-home safety plan, knowing she lacked an adequate support structure. A third-party cross-claim. If the medical defendants could prove Patrick was negligent, they would likely file a cross-claim against him. This would legally force the medical malpractice trial to decide how to split the blame between the negligent doctors, who prescribed the drugs, and a negligent husband, who left her unmonitored. 3. Connections to broader women's health and medication litigation. If the case pivoted toward investigating the husband's duty of care, it would deeply intersect with broader national legal debates regarding maternal health care, medical paternalism, and the invisible burden of women's health. The delegation of clinical care precedent. In modern outpatient psychiatry, doctors heavily rely on spouses to monitor a patient's behavioral changes and enforce medication compliance. If Patrick's responsibility were legally questioned, this case would set a massive legal precedent regarding exactly how much clinical burden a hospital can legally shift onto a spouse. Women's health advocates argue it is systemic medical neglect to give a mother a highly volatile medication cocktail and expect an untrained spouse to act as a 24/7 psychiatric ward monitor. Shifting the blame from system to family. Historically, in litigation involving severe postpartum psychiatric emergencies, defense teams for medical networks have attempted to scrutinize the domestic dynamic to deflect from pharmaceutical or clinical oversight failures. Legally questioning the husband risks validating a dangerous cultural double standard, punishing the family unit for failing to manage an emergency medical crisis that the medical system itself failed to accurately diagnose, such as her undiagnosed bipolar II disorder. In plain terms, this argument is trying to establish a legal shield between the mental health providers and the later crime committed by their patient. But that shield is generally not absolute. The key question is usually whether the providers had a legally recognized duty to protect or warn someone and whether their conduct fell within the protections provided by Massachusetts law. What the defense attorneys are arguing. The statement is essentially saying that the medical or mental health providers are asking the court to throw out Patrick Clancy's lawsuit before it reaches a trial because Massachusetts law gives mental health professionals unusually strong protection from lawsuits based on a patient's later violent acts. The central law is Massachusetts General Laws, Chapter 123, Section 36b. Under that statute, A licensed mental health professional generally has no legal duty to warn or protect a potential victim from a patient, and therefore generally cannot be sued for failing to do so, unless very specific conditions are met. Massachusetts Legislature. The two major exceptions. A lawsuit may potentially proceed if the plaintiff can show one of the following. First, the patient made an explicit threat to kill or seriously injure a reasonably identifiable person. The provider believed the patient had the apparent intent and ability to carry out that threat, and the provider failed to take reasonable precautions. Second, the provider knew the patient had a history of physical violence, had a reasonable basis to believe there was a clear and present danger that the patient would kill or seriously injure a reasonably identifiable victim, and failed to take reasonable precautions. Massachusetts Legislature. That phrase, reasonably identified victim, is especially important. It generally is not enough to argue simply that the patient was dangerous or unpredictable. The plaintiff may need to establish that there was a sufficiently identifiable person, or identifiable group of potential victims, who faced the danger. Why this is a powerful defense. Massachusetts courts have interpreted Section 36B quite strongly. In Shea v. Caritas Carney Hospital, the Massachusetts Appeals Court concluded that if the statutory requirements are not met, there is generally no duty to warn or protect, meaning the negligence claim can fail as a matter of law. The court rejected an attempt to create a broader common law duty outside the statute. Just a law. In practical terms, the defense may be arguing something like, even if the outcome was tragic, the law does not automatically make a therapist, psychiatrist, or other mental health provider legally responsible for a crime committed by their patient. Unless the facts fit one of the narrow exceptions in the Massachusetts statute, there was no legal duty to protect the eventual victim. That is why this can be described as an ultimate defense shield. If the judge agrees that Section 36B applies and that none of its exceptions are satisfied, the lawsuit, or at least the claims based on failure to warn or protect, could potentially be dismissed without a jury deciding whether the providers acted negligently. But it is not necessarily absolute immunity. There is an important distinction between saying providers are immune from all lawsuits and saying Massachusetts law limits liability for a specific type of claim. Section 36B primarily addresses claims that a mental health professional failed to warn or protect a third party from a patient's violence. Other theories of liability may involve different legal questions depending on the facts, for example, an institution's independent duties or responsibilities involving a patient in its actual custody. The Massachusetts Supreme Judicial Court has recognized that, in certain circumstances, a hospital may have duties distinct from the individual clinician's duty to warn, although those duties can be narrowly limited. Just a law. So the crucial issue in Patrick Clancy's case would likely be exactly what the providers knew, when they knew it, what the patient communicated to them, whether there was an identifiable victim, and what actions the providers took. The defense's motion to dismiss does not necessarily mean the court has agreed with them. It means they are asking the judge to decide that, even accepting the legally relevant allegations of the complaint, Massachusetts law does not permit the lawsuit to proceed under the theory being asserted. The legal battle may therefore come down to one question. Did the facts meet Massachusetts's narrow statutory threshold for creating a duty to warn or protect someone from the patient? If the answer is no, the providers have a potentially formidable defense. If the answer is yes, or if the lawsuit asserts a legally viable duty outside the particular protection, the case may survive dismissal and move forward. The defense lawyers for the medical providers could investigate Patrick's own actions and possible responsibility, especially if Patrick is the plaintiff or if his conduct is relevant to how the injury or death occurred. This is a normal part of defending a civil lawsuit. They could use several methods to do that if the case survives the motion to dismiss and enters discovery. Massachusetts discovery rules allow parties to seek non-privileged information relevant to the claims or defenses, including documents, electronic evidence, witnesses, interrogatories, and sworn depositions. Massachusetts government. Depending on the allegations in the case, the defense might investigate questions such as 1. What did Patrick know, and when did he know it? 2. What actions did he take, or fail to take, that may have contributed to the events or damages? 3. Did he receive warnings, information, or instructions that he ignored? 4. Did he communicate with the patient, providers, police, family members, or others? 5. Are there texts, emails, social media posts, recordings, or witnesses relevant to his actions? 6. Did his own conduct contribute to the injury or loss for which he is seeking damages? This does not mean the defense can simply conduct an unlimited investigation into Patrick's entire life. The information sought generally has to be relevant to the lawsuit, and courts can limit discovery that is overly burdensome, oppressive, or outside the legitimate scope of the case. Massachusetts government. Comparative negligence could be important. If Patrick is personally claiming damages for injuries or losses, the defendants could potentially argue comparative negligence, that Patrick himself acted negligently and that his actions contributed to the harm. Under Massachusetts law, the defendant bears the burden of proving the plaintiff's comparative negligence. If the plaintiff's negligence contributed to the injury, damages can be reduced proportionally, and if the plaintiff's negligence is greater than the combined negligence of the defendants, recovery can be barred. Massachusetts legislature. There is also an important distinction depending on Patrick's role in the lawsuit. If Patrick is suing as a representative of someone who died, the legal question may not simply be whether Patrick himself was negligent. The defense would instead look at whose conduct legally contributed to the damages and what claims Patrick is bringing. So, strategically, the medical provider's lawyers could potentially investigate two separate issues at the same time. 1. The statutory defense. Did Massachusetts law impose any duty on the providers to warn or protect against the patient's actions? 2. Patrick's conduct. Even if the providers had some duty, did Patrick's own actions, decisions, knowledge, or conduct contribute to what happened or affect the damages he is claiming? The exact significance would depend heavily on the complaint and Patrick's relationship to the victim. If you provide the lawsuit or the motion to dismiss, I can break down exactly what Patrick is being alleged to have done, what the defense is arguing, and whether his own actions could realistically become an issue in the case. Civil case defense lawyers might try to question or obtain evidence about the relationship if they believed it was relevant to damages. If Patrick is seeking compensation for emotional distress, loss of companionship, financial loss, or the effect the event had on his personal life, the defense may examine evidence bearing on those claimed damages. Timeline and circumstances. If the timing of the new relationship is connected to events alleged in the lawsuit, the defense could ask about it. Knowledge or communications. If his wife knew something relevant, witnessed events, received messages, or discussed the situation with Patrick, she could potentially be a fact witness. Alternative explanations for damages. Defense attorneys sometimes investigate whether other events or relationships may explain emotional or financial harm being claimed. Credibility or inconsistent statements. If Patrick made statements about his relationship that directly contradict claims he is making in court, those statements could potentially become relevant. However, they generally cannot just ask intrusive questions because they are curious, suspicious, or want to embarrass him. A lawyer could object, and the court could limit questioning that is irrelevant, overly invasive, or intended primarily to harass. One important distinction is whether Patrick is claiming damages based on the loss of a previous spouse or partner. If he is, the defense may have a stronger argument that his subsequent marriage or relationship is relevant to certain aspects of his claimed losses. But even then, it would not automatically mean that every detail of the new marriage becomes open for investigation. So the short answer is, yes, the relationship with his new wife could potentially be questioned, but only if the defense can connect it to an actual issue in the lawsuit, such as damages, timeline, knowledge, communications, causation, or credibility. Could the defense investigate or introduce evidence that Patrick and Lindsay were experiencing marital problems, and, if relevant evidence existed, investigate whether Patrick was involved in an affair that may have contributed to Lindsay's emotional deterioration? Even if she did not know about the affair? Potentially, yes, but only if the defense could establish that the information is relevant to an actual issue in the lawsuit. The key issue would not simply be whether Patrick was cheating. It would be whether problems within the marriage, emotional distance, deception, conflict, or other stressor could have contributed to Lindsay's mental state and therefore challenge the lawsuit's claim that the defendant's medical treatment was the cause of her deterioration. For example, the defense might explore whether Patrick and Lindsay were experiencing significant marital strain. Lindsay had expressed feeling that Patrick was emotionally distant or withdrawing from the relationship. There were arguments, separation concerns, trust issues, or other relationship stressor. Lindsay communicated distress about the state of her marriage to friends, family, therapists, or medical providers. Patrick was involved in another relationship during the marriage, if there were a factual basis to investigate that possibility. Any deception or emotional distance had an effect on Lindsay's mental condition, even if she did not know the precise reason for Patrick's behavior. That last point is important. Lindsay would not necessarily have needed to know about an alleged affair for the issue to potentially matter. If, hypothetically, Patrick was emotionally withdrawing because of another relationship and Lindsay experienced that withdrawal as rejection, abandonment, or unexplained distance, the defense might argue that the marital stress was part of the overall context surrounding her deterioration. The legal argument would be less about assigning moral blame and more about causation. Was Lindsay's deterioration caused exclusively or primarily by negligent psychiatric treatment, as the lawsuit alleges, or were there other significant personal and environmental factors contributing to her condition? If Patrick's complaint presents the provider's treatment as the central cause of her decline, the defense could have reason to investigate alternative contributing causes. Evidence of serious marital problems could potentially be relevant to that question. However, there would need to be some factual basis. Defense lawyers generally cannot conduct an unlimited fishing expedition into allegations of infidelity merely because an affair would be embarrassing or potentially damaging. A court could limit discovery that is speculative, irrelevant, or unduly invasive. If evidence existed, for example, messages, witnesses, financial records, communications, or other information suggesting a relationship or serious marital difficulties, the defense could potentially seek discovery and argue that it is relevant because Patrick's own personal relationship with Lindsay may be part of the causal story that the jury is being asked to evaluate. There is also a potentially separate issue involving Patrick's knowledge of Lindsay's condition. The defense could examine whether marital problems affected what Patrick observed, what Lindsay communicated to him, and what he chose to communicate to her medical providers. So, in theory, the defense could pursue a line of inquiry along these lines. The plaintiff alleges that the defendants failed to recognize and respond to the factors causing Lindsay's deterioration. But were there significant stressors within her marriage that also contributed to her emotional state? What did Patrick know about those stressors, and what information did he provide, or fail to provide, to her medical providers? Whether a judge would ultimately allow evidence of an alleged affair to be presented to a jury would depend on the evidence itself and its connection to causation, damages, credibility, or another disputed issue. Mere speculation or character attacks would be much less likely to be admissible. Yes, but there is an important distinction between the trial raises questions about why Patrick wasn't investigated, and the trial establishes evidence that Patrick should have been investigated. The former could potentially be useful to civil attorneys. The latter would require actual evidence. As of August 26, 2026, Patrick has not been charged, and reporting about why he was not charged says prosecutors concluded there was insufficient evidence of the necessary criminal culpability. At the same time, the current trial has generated public questions about the investigation, Patrick's testimony, the timeline, and what investigators did or did not examine. Those questions by themselves aren't proof of misconduct. How this could affect Patrick's civil lawsuit? This is where it gets interesting. Patrick's civil lawsuit is based on the theory that the medical provider's negligence caused or substantially contributed to Lindsay's deterioration and the deaths of the children. His complaint alleges, among other things, that the providers prescribed numerous psychiatric medications and failed to adequately recognize or respond to Lindsay's deteriorating condition. The defendants therefore have an obvious interest in identifying all potentially relevant causes of Lindsay's deterioration, not merely the medications. If evidence emerged during the criminal trial suggesting that there were significant circumstances involving Patrick that were previously unexplored, such as marital conflict, communications, undisclosed relationships, unexplained changes in Lindsay's behavior, or discrepancies in the timeline, the civil defendants could potentially pursue those issues through discovery. But they would need to connect him to the lawsuit. For example, imagine the trial produced evidence showing 1. Lindsay repeatedly told people she felt emotionally abandoned or disconnected from Patrick. 2. There was evidence of significant marital conflict that had not previously been disclosed. 3. Evidence emerged concerning another relationship or possible infidelity. 4. That information could be tied to Lindsay's emotional state. 5. Patrick knew about some of these circumstances but they weren't communicated to the medical providers. 6. Patrick's civil complaint nevertheless attributes Lindsay's deterioration primarily to the provider's treatment. That could give the defense a legitimate reason to say, We need to investigate whether there were additional circumstances contributing to Lindsay's deterioration that are relevant to causation. That's substantially different from saying, Patrick must be guilty because he had marital problems. And the defense could potentially use the criminal trial itself. Civil attorneys can obtain and examine evidence generated during a criminal proceeding, subject to rules governing admissibility, privilege, discovery, and the particular source of the evidence. They could look at things such as 1. Patrick's testimony. 2. Prior statements Patrick made to investigators. 3. Police reports. 4. Text messages and other communications introduced into evidence. 5. Medical records. 6. Witness testimony. 7. Timeline evidence. 8. Statements Lindsay made to other people. 9. Evidence concerning the couple's relationship. 10. Evidence concerning what Patrick knew about Lindsay's condition. 11. Any inconsistencies between Patrick's testimony and documentary evidence. If something comes out at trial that materially contradicts Patrick's civil complaint or deposition testimony, that could become particularly important. There's another major issue, Patrick's role as a witness. This may actually be more significant than whether he was investigated. Patrick is simultaneously the father of the deceased children, right-pointing arrow, the plaintiff in the wrongful death litigation, right-pointing arrow, a major witness concerning Lindsay's condition, right-pointing arrow, and someone who was closely involved in Lindsay's treatment and home life. That means the defendants can potentially scrutinize his account of what happened. For example, what did Patrick know about Lindsay's mental condition? When did he know it? What did Lindsay tell him? What did he tell her doctors? What did he not tell them? Were there circumstances in Lindsay's personal life that the providers were unaware of? Those questions could go directly to the defense's argument that the providers did not have the complete picture that Patrick now says they should have recognized. But here's the important limitation. The civil lawyers cannot simply tell a jury. People on the internet think Patrick wasn't properly investigated. That would be extremely weak evidence and potentially inadmissible. Nor would the fact that Patrick wasn't charged establish that he did something wrong. What matters is whether the criminal trial uncovers actual admissible evidence that changes the factual picture. If the trial produces genuinely new evidence, rather than speculation, that suggests investigators overlooked relevant witnesses, communications, relationship circumstances, or contradictory evidence, that could absolutely give the civil defense lawyers a reason to investigate those matters themselves. And there's an important strategic wrinkle here. The medical defendants may actually want to know everything about Lindsay's circumstances before the tragedy. If they can demonstrate that significant factors outside their treatment contributed to her deterioration, that could strengthen their causation defense. Conversely, if the trial evidence shows that Patrick repeatedly warned providers about Lindsay's deterioration and gave them information that should have triggered intervention, that could potentially strengthen Patrick's civil case. So the criminal trial could cut either way for the civil lawsuit. The most consequential question isn't really, why wasn't Patrick investigated? It's, does the evidence emerging from the criminal trial reveal facts about Patrick, Lindsay, their relationship, or their communications that materially change the causation story presented in Patrick's civil complaint? The defense lawyers in the civil case could potentially use that evidence, but I would be careful about what it actually proves. First, there appears to be an important correction to the premise. The trial testimony does not establish that Patrick did not go into CVS. The testimony establishes the opposite. Patrick testified that he went into CVS. And surveillance showed him entering at about 5:32 p.m. He also testified that he called Lindsay while inside because the medication they were looking for wasn't on the shelves. The separate issue is the 5:24 p.m. work email. Patrick acknowledged sending an email to co-workers at 5:24. He said he wasn't sure whether it was sent from his Surface Pro or his iPhone. Prosecutors then established that he was outside the house at that time and asked whether he could have sent it from his phone while sitting in his car before entering CVS. Patrick said that was possible. Could the civil defense use this? Potentially, yes, but probably not to prove that Patrick wasn't concerned about leaving Lindsay alone. The more legitimate use would be to examine Patrick's state of knowledge and behavior immediately before leaving the house. The defense could ask, what did Patrick know about Lindsay's condition when he left? What did Lindsay say to him immediately before he left? Did he have any reason to believe she was dangerous to herself or the children? Did he express concern about leaving her alone with the children? What did he tell the medical providers about her condition? What did he understand about the risks associated with her mental state? That could become relevant because Patrick's civil lawsuit argues that the medical providers should have recognized and responded to Lindsay's deteriorating condition. The email could be used as part of the timeline. The interesting part for the civil defense isn't necessarily, Patrick sent an email. It's the combination of 5:15-ish, Patrick leaves the house. 5:24, work email is sent. 5:32, Patrick enters CVS. 5:32 to 5:37, he is inside CVS and communicates with Lindsay. 5:54, he is at 3V. 6:09, he returns home. The trial evidence currently supports that general sequence. If the civil defendants were trying to understand what Patrick knew and believed at each point, they could certainly examine that timeline. But the email timestamp does not establish where Patrick was when he sent it, because he testified that it could have been sent from his iPhone. And the prosecution itself suggested the possibility that he sent it from his car before entering CVS. Could they argue that he wasn't sufficiently concerned about Lindsay? They could try, but that's a much bigger evidentiary leap. For example, the defense might argue, if Patrick genuinely believed Lindsay was in an acute psychiatric crisis and posed an immediate danger to herself or the children, why did he leave her alone with 3 children? That is a legitimate question for lawyers to investigate. But they would need evidence showing what Patrick actually knew at that moment. If Patrick had been told something like, "I am afraid I might hurt myself or the children," immediately before he left, then leaving her alone would look very different than if she appeared to be improving, functioning normally, and asking him to make an ordinary CVS run. And this distinction is especially important because Patrick testified that January 24th was one of Lindsay's best days, and prosecutors questioned him about her apparent improvement following her McLean hospitalization. So the civil lawyers could potentially investigate whether Patrick's actions were consistent with what he says he knew about Lindsay's condition. Where this could become significant for the civil lawsuit. The medical defendants could potentially construct an argument like this. Patrick is claiming that the providers should have recognized that Lindsay was dangerous. But what did Patrick himself observe? What did Lindsay actually look and act like on January 24th? What did Patrick know when he left her? And what information did he give the providers? That's much stronger legally than Patrick sent an email, therefore he wasn't concerned. The email could become one piece of the larger chronology. And if there were additional evidence, texts, medical records, witnesses, surveillance, phone data, or Patrick's own prior statements, showing that he believed Lindsay was doing well enough to be left with the children, the defense could potentially use that to challenge the argument that her dangerous deterioration was obvious or foreseeable. One other interesting piece of evidence. The trial has also explored the couple's relationship. For example, Patrick testified about a planned Boston anniversary trip in December 2022 that was ultimately cancelled. That doesn't establish marital problems or infidelity. But if the civil defendants are examining Lindsay's mental state and potential causes of her deterioration, they could potentially investigate the broader circumstances of the marriage if they have a legitimate factual basis for doing so. So I would frame the issue this way. The 524 email by itself doesn't show Patrick was unconcerned about Lindsay. But the complete timeline, including what Patrick knew before leaving, what Lindsay communicated to him, his decision to leave her with the children, his communications while away, and what he told medical providers, could potentially become relevant evidence in the civil lawsuit. And importantly, the current trial has not established that Patrick did anything wrong by leaving the house or sending the email. The email discrepancy has generated public speculation, but the evidence presented so far does not establish wrongdoing from the timestamp alone. If the reporting is accurate that the crushed pills in a drink information came from Patrick's account and that the drink itself was never tested, that distinction could be important in the civil case. The strongest way the medical provider's lawyers could use it would not be to assert that the drink definitely contained crushed medication. They could use it to question the evidentiary basis for the story and Patrick's observations, and potentially to investigate whether the circumstances surrounding Lindsay's alleged overdose were accurately understood. What the evidence appears to establish. According to testimony reported this week, forensic psychiatrist Dr. Gregory Sarthoff testified that Patrick told him he found a wine tumbler containing residue from crushed medication. Sarthoff also testified that Lindsay described drinking lemonade from the tumbler when she took the pills. But on cross-examination, the defense established an important limitation: the contents of the tumbler were never tested. Sarthoff also said he was not aware of any object used to crush the pills being recovered. And investigators apparently did not know at the beginning of the investigation that Lindsay had crushed pills as part of the alleged overdose. That information came later through Patrick's account. So there is a significant distinction between Patrick reported seeing crushed medication in a tumbler, and investigators scientifically established that the tumbler contained crushed medication mixed with lemonade. Those are not equivalent. How could the civil defense use that? The medical provider's attorneys could potentially use the issue in several different ways. 1. Questioning the reliability of the evidence. If Patrick's observation is the primary source for the crushed pill drink account, the defense could ask, how do we know what was actually in the tumbler? If there was no toxicology or chemical testing of the liquid or residue, there may be no independent scientific confirmation of exactly what the substance was. That doesn't mean Patrick was lying. It means the defense could distinguish an eyewitness observation from independently verified physical evidence. That distinction could matter when reconstructing Lindsay's mental state and actions. 2. Questioning the reconstruction of Lindsay's suicide attempt. Patrick's civil lawsuit is fundamentally concerned with what caused Lindsay's deterioration and whether the medical providers failed to recognize or treat it appropriately. The defense could therefore examine the alleged overdose as part of the larger chronology. For example, what exactly did Lindsay ingest? How much did she ingest? When did she ingest it? What medication was allegedly involved? Was it actually found in the tumbler? Was the substance tested? What did Patrick personally observe? What did Lindsay actually tell Patrick? What did she subsequently tell doctors? Those questions could become relevant because the prosecution's expert, Sarthoff, considered the alleged crushing and mixing of the pills significant to his assessment of Lindsay's decision-making. If the physical evidence doesn't independently establish the story, the civil defendants could challenge how confidently conclusions are being drawn from it. 3. Potentially investigating Patrick's account. This is where it could become more interesting for the civil defendants. Suppose Patrick is an important witness in the civil lawsuit and his complaint relies heavily on his observations of Lindsay's deterioration. The defense could potentially ask, what did you personally see? Versus, what did you learn later from someone else? Those are legally very different things. If Patrick actually saw powder inside a tumbler, that's first-hand evidence of what he observed. But if the assertion that it was medication, that it was mixed with lemonade, and that it was part of an overdose comes from later statements or assumptions, the defense could attempt to separate those layers of information. That could be particularly relevant if Patrick's account is being used to establish what Lindsay was doing or experiencing. 4. The lemonade question could be significant. There is another interesting discrepancy. Sarthoff testified that Lindsay said she had used lemonade to take the crushed pills, and that the lemonade had supposedly been left in the tumbler from the night before. Patrick reportedly told Sarthoff that lemonade was not something they normally kept in the house. That doesn't prove anything sinister. But from a civil defense perspective, it creates a fact that can be investigated. Where did the drink come from? When was it made? Who knew about it? And what exactly did Patrick observe when he returned? If those details matter to reconstructing the overdose or Lindsay's state of mind, the defense could potentially explore them. 5. It could affect the argument about Lindsay's psychiatric deterioration. This is probably the most important connection to the civil case. Patrick's lawsuit essentially asks the jury to accept a causal chain. Medical treatment right pointing arrow worsening psychiatric condition right pointing arrow catastrophic event. The defendants will want to examine every part of that chain. If the overdose evidence is uncertain, they could potentially argue, there are substantial uncertainties about exactly what happened during Lindsay's suicide attempt and what evidence supports the reconstruction of that event. The jury should therefore be cautious about using that reconstruction to establish the nature and progression of her psychiatric condition. Again, that doesn't necessarily defeat Patrick's lawsuit. Medical records, prescriptions, witness testimony, and other evidence could independently establish her deterioration. But there is an even bigger issue. The fact that the drink wasn't tested cuts both ways. The civil defense could say, there is no scientific evidence establishing what was in that tumbler. But Patrick's lawyers could respond, the absence of testing doesn't mean Patrick's observation was false, and the medical records and other evidence independently demonstrate Lindsay's severe psychiatric deterioration. And they could argue that the question isn't whether a laboratory proved the drink contained medication, but whether the providers had enough information about Lindsay's condition to recognize the danger. The really important distinction. I would therefore avoid saying, the crushed pill drink was fabricated by Patrick. There is currently no evidence establishing that. A more defensible observation is, the trial testimony indicates that the crushed pill drink account was based substantially on what Patrick reported seeing, while the tumbler's contents were not scientifically tested and investigators did not initially know that Lindsay had allegedly crushed and ingested pills. That is potentially significant for the civil case because Patrick is also the plaintiff whose account of Lindsay's condition and the events surrounding her deterioration may be scrutinized by the medical defendants. If the civil case proceeds into discovery, the defendants could potentially seek the underlying police reports, photographs, laboratory records, medical records, interviews, and testimony concerning that tumbler and determine exactly what is first-hand evidence, what came from Patrick, what came from Lindsay, and what was inferred afterward. That distinction could be much more consequential than the simple question of whether the drink was tested. Lindsay's civil case does not legally depend on Patrick winning his wrongful death case, and Patrick's criminal, civil outcome is not a prerequisite for Lindsay's malpractice case. In fact, the two civil cases can proceed independently. There are currently separate civil lawsuits, Patrick's wrongful death action, filed individually and as representative of the children's estates, and Lindsay's own medical malpractice action against providers involved in her care. But the two cases are closely connected. The interesting part is that both cases are built around essentially the same underlying medical treatment story, whether Lindsay's psychiatric treatment contributed to her deterioration and whether the providers failed to recognize or appropriately respond to what was happening. Patrick's complaint alleges that the providers' treatment exacerbated Lindsay's mental health problems and that their negligence contributed to the children's deaths. Lindsay's case, by contrast, can focus much more directly on what happened to Lindsay herself, her treatment, medications, psychiatric deterioration, injuries, and the alleged negligence of the providers. So Patrick doesn't have to win first. What happens if Patrick loses? This is where it gets complicated. If Patrick loses because a judge or jury concludes the medical providers were not negligent, that could obviously be very damaging to Lindsay's malpractice case, because both cases involve overlapping allegations about the provider's conduct. But it would not necessarily legally end Lindsay's case. The reason is that Lindsay's claims and Patrick's claims aren't identical. They involve different plaintiffs, different legally cognizable injuries, and potentially different theories of damages. For example, Patrick's case asks whether the provider's negligence contributed to the deaths of the children. Lindsay's case can ask whether the provider's negligence caused or contributed to Lindsay's own psychiatric deterioration and catastrophic injuries. Those are related, but not necessarily identical, questions. And the criminal trial could actually be important to Lindsay's civil case. This is where the current trial becomes particularly interesting. The defense in the criminal case is arguing that Lindsay experienced severe postpartum psychiatric illness and that medication and inadequate psychiatric treatment contributed to her condition. The current trial has included extensive testimony about medication, psychiatric symptoms, treatment decisions, and the provider's recognition, or failure to recognize, her condition. Those facts overlap substantially with the medical malpractice allegations. So Lindsay's lawyers don't necessarily need Patrick to establish everything for them. The criminal trial itself is generating evidence that could potentially be relevant to her civil malpractice claim. There is an important strategic possibility. If Lindsay's criminal defense succeeds in establishing something like, Lindsay was suffering from a severe psychiatric disorder, right pointing arrow her treatment, medications contributed to that condition, right pointing arrow the condition substantially impaired her judgment or responsibility. That could potentially be helpful to Lindsay's civil malpractice case. It could support the argument that her psychiatric deterioration was real, severe, and medically significant, and that the providers should have recognized and treated it differently. But there is an important caveat. Winning the criminal case would not automatically mean Lindsay wins the malpractice case. Criminal responsibility and medical negligence use different legal standards. Likewise, if Lindsay is found criminally responsible, that wouldn't automatically prove that her doctors weren't negligent. Patrick's lawsuit could actually create an interesting problem. Patrick's complaint places substantial emphasis on the proposition that the medical providers caused or contributed to Lindsay's deterioration. Lindsay's civil case can make a similar argument about her own injuries. But if Patrick's attorneys discover evidence during litigation that complicates that narrative, for example, evidence concerning Lindsay's personal circumstances, what Patrick knew, what Lindsay told Patrick, or what happened immediately before January 24th. That evidence could potentially become relevant to both cases. And this connects directly to your previous question about the criminal trial. If the criminal trial produces evidence that raises legitimate questions about the timeline, Patrick's observations, communications between Patrick and Lindsay, or the accuracy of particular accounts, Lindsay's civil lawyers and the medical defendant's lawyers could potentially examine that evidence independently. The simplest way to think about the three cases. Criminal case. Was Lindsay criminally responsible for the deaths? Patrick's civil case. Were the medical providers negligent, and did that negligence contribute to the children's deaths and Patrick's legally compensable losses? Lindsay's civil case. Were the medical providers negligent, and did that negligence contribute to Lindsay's psychiatric deterioration and resulting injuries, losses? They overlap heavily, but none is legally dependent on another being one first. And given what has emerged during the current trial, I think the most consequential issue for Lindsay's civil case may ultimately be not whether Patrick wins, but whether the trial produces admissible evidence establishing a stronger causal connection between the provider's treatment and Lindsay's deterioration. The current testimony has included both evidence favorable to that theory, such as testimony about medication effects and inadequate recognition of postpartum psychiatric illness, and evidence the prosecution uses to challenge the defense's characterization of Lindsay's condition.